Committee rejects alternative claims for damages introduced by Primeo for the first time on appeal, and also rejects a new defence introduced for the first time by the defendants on appeal. In accordance with the principle of finality in litigation, a party is required to advance its whole case at trial and may not introduce new claims or defences on appeal. Considering next the question whether Primeo brought its claim in time, the relevant time limit in the Cayman Islands is 6 years. However, the relevant legislation, which is in the same terms as the corresponding legislation in England and Wales, postpones the running of time where there has been a deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time. The Judicial Committee holds that recklessness as to whether a breach of duty has been committed does not amount to the deliberate commission of a breach of duty. Primeo cannot show that either of the defendants deliberately breached the duties they owed it. Therefore, any of Primeo's rights of action against the defendants, which arose more than 6 years before it brought its claim in 2013, and which are based on the fault of the defendants, are time-barred. However, the legislation also postpones the running of time where there has been fraud on the part of the defendant's agent. On that basis, the Judicial Committee holds that Primeo's claims in respect of HSBC's responsibilities as custodian are not time-barred, since there was fraud and deliberate concealment of relevant facts by Bilmis, which acted as HSBC's agent in fulfilling the obligations that HSBC owed to Primeo as the custodian of its assets. Considering finally the question of contributory negligence, the relevant legislation is again modelled on UK law and provides for damages to be adjusted where there has been fault on the part of a claimant, and the case is one in which the defence of contributory negligence would have been available at common law. The Judicial Committee holds that prior to 1945, when the UK legislation was introduced, contributory negligence was available under the common law as a defence to a claim based on a breach of contract, where there existed concurrent claims in contract and in tort for breach of a duty of care, and where negligence was an essential ingredient of both rights of action. The statutory defence of contributory negligence relied on is available in similar circumstances. It is not necessary that the claimant sues on a right of action in tort. It's sufficient that the right of action is founded on an act or omission which would give rise to liability in tort. On the facts, the Judicial Committee holds that the defence of contributory negligence is not available to HSBC because its duties in contract were not the same as any concurrent duty in tort. In respect of a claim against Bank of Bermuda, where the defence does apply, the Judicial Committee holds that the Court of Appeal was right to allow Primeo's appeal against a reduction of 75% in its damages as decided by the judge, and to rule instead that a reduction of 50% was appropriate, because the judge had not attached proper weight to the fact that Bank of Bermuda was a professional service provider which was as much at fault as Primeo in causing the damage.
Judgment in the matter of Canada Square Operations Limited against Potter.
This appeal raises an important point of law which will affect many thousands of people. The case concerns the mis-selling of PPI policies by banks and is a test case on which around 26,000 other claims depend. Mrs. Potter took out a loan with Canada Square, which was then known as Egg Banking. She also took out a PPI policy and paid a premium for the policy of just under £4,000. Unknown to her, over 95% of that amount was retained by Canada Square as its commission. The amount paid to the insurance company was only £182. Mrs. Potter did not find out about the commission until 2018, 8 years after the loan had been repaid. She then began proceedings against Canada Square to recover the amount she had paid, but she was met with a defence that her claim had been brought too late. The statutory time limit for bringing a claim of that kind is 6 years, so at first sight she was too late. However, the statute postpones the running of the 6-year period where any fact relevant to the claimant's right of action has been deliberately concealed from her by the defendant. It also provides that the deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. So far as deliberate concealment is concerned, previous Court of Appeal decisions have held that there can only be concealment if there is a duty to reveal the fact in question. Canada Square was under no legal duty to reveal the commission, but the Court of Appeal held that it was enough if there was a moral or social duty and found in Mrs. Potter's favour on that basis. Canada Square appeals against that finding. So far as the deliberate commission of a breach of duty is concerned, Mrs. Potter accepts that she cannot prove that Canada Square intentionally acted in breach of duty, but she argues that it is enough that they did so recklessly. The Court of Appeal accepted that argument, and Canada Square appeal against that finding also. This court unanimously holds in relation to deliberate concealment that a fact is concealed if the defendant has kept it secret from the claimant, either by taking active steps to hide it or by failing to disclose it. Contrary to previous Court of Appeal authority, the claimant does not need to establish that the defendant was under a legal, moral, or social duty to disclose the fact, nor does she need to show that the defendant knew that the fact was relevant to the claimant's right of action. All that is required is that the defendant deliberately ensures that the claimant does not know about the fact in question, and so cannot bring proceedings within the ordinary time limit. Turning to the meaning of deliberately, the court holds that the defendant's concealment of a relevant fact will be deliberate if the defendant intended to conceal the fact in question. The court rejects the Court of Appeal's finding that deliberately can also mean recklessly in this context. On the evidence in this case, Canada Square concealed the commission from Mrs. Potter and did so intentionally. The 6-year time limit for bringing her claim did not, therefore, begin to run until she found out about the commission in 2018. Her claim was, therefore, brought in time. In relation to the deliberate commission of a breach of duty, the court unanimously rejects the argument which the Court of Appeal upheld that something which is done recklessly is done deliberately. Deliberate and reckless have different meanings, both in ordinary language and in the context of legislation. Canada Square therefore succeeds on that argument, but it does not affect the outcome, because Mrs. Potter succeeds on the issue of deliberate concealment. Canada Square's appeal is therefore dismissed. The result will have important implications for thousands of other PPI claims against banks, and the clarification of the law governing the time limits for bringing court proceedings will also affect many more claims in the future.
Judgment in the matter of the Crown on the application of AAA and others against the Secretary of State for the Home Department and 5 other appeals.
This appeal is concerned with the Home Secretary's policy concerning asylum seekers and Rwanda. It's important at the outset to understand what exactly that policy is. It is not, as is sometimes thought, a policy of sending asylum seekers overseas while their claims for asylum in the UK are processed by the UK authorities. The Home Secretary's policy is that people claiming asylum in the UK will not have their claims decided by the UK authorities. Instead, they will be sent to Rwanda, where they can claim asylum in Rwanda. Their claims will be decided there by the Rwandan authorities. If their claims are successful, they will be granted asylum in Rwanda. If their claims are unsuccessful, Rwanda is entitled to expel them from its territory. In this appeal, the Supreme Court is required to decide whether that policy is lawful. That is a legal question which the court has to decide on the basis of the evidence and established legal principles. The court is not concerned with the political debate about the policy, and nothing in its judgment should be regarded as supporting or opposing any political view of the issues. In view of the public importance of this appeal, the court has expedited the production of its judgment and as a result is able to give judgment within a shorter period of time than in most of its cases. There is a legal rule that refugees must not be returned to their countries of origin, either directly or indirectly, if their life or freedom would be threatened in that country. That rule is called the principle of non-refoulement. One of the consequences of the rule is that asylum seekers cannot be returned to their countries of origin without a proper consideration of their claims, since asylum seekers whose claims have not been properly considered could well be genuine refugees. And as I've explained, refugees must not be returned to their countries of origin. This legal principle of non-refoulement is laid down in the United Nations Refugee Convention, to which the UK is a party. There are also provisions which have the same effect in other treaties to which the UK is a party. The UN Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment, the UN International Covenant on Civil and Political Rights, and the European Convention on Human Rights. It is therefore not only the European Convention on Human Rights which is relevant to this case, as is sometimes thought. There are other international treaties which also prohibit the return of asylum seekers to their countries of origin without a proper examination of their claims. These international treaties are reflected in our domestic law. In the first place, there are several Acts of Parliament which give effect to the principle of non-refoulement as set out in the UN Refugee Convention. They include the Asylum and Immigration Appeals Act of 1993, the Nationality, Immigration and Asylum Act of 2002, and the Asylum and Immigration Treatment of Claimants, etc. Act of 2004. There is also an Act of Parliament, the Human Rights Act of 1998, which gives effect to the European Convention on Human Rights. Again, contrary to what is sometimes thought, the Human Rights Act is not the only relevant legislation. The effect of the legislation, in general terms, is to prohibit the removal of asylum seekers whose claims have not been decided to a country where there are substantial grounds for believing that they would be at real risk of refoulement. The issue the court has to decide is whether the Home Secretary's policy breaches that prohibition. For the asylum claims with which this appeal is concerned, the basis of the Rwanda policy is contained in the Home Secretary's immigration rules, which are statements of administrative practice. Under those rules, asylum claims can be treated as inadmissible if the claimants had the opportunity to apply for asylum in a safe third country but did not do so. The claimants can then be removed to any safe third country which agrees to accept them. A country only qualifies as a safe third country under the rules if the principle of non-refoulement is respected there, in accordance with the UN Refugee Convention. It is the next step which is controversial in these proceedings. That is the Home Secretary's guidance to the officials who apply the rules that Rwanda is a safe third country. That is to say, a country where asylum seekers will not be at risk of refoulement, her certificate, and also her certificates to that effect under the relevant legislation. There is no dispute between the Home Secretary and the claimants in this case as to the legal test which the court has to apply. The test is whether there are substantial grounds for believing that asylum seekers who are sent to Rwanda will be at real risk of ill treatment as a consequence of refoulement. If there are no such grounds, the policy is lawful. If there are such grounds, the policy is unlawful. It is argued on behalf of the Home Secretary that there are no substantial grounds for believing that asylum seekers who are sent to Rwanda will be at risk of refoulement. A memorandum of understanding has been entered into between the UK and Rwandan governments, which includes an undertaking that asylum seekers will not be subject to refoulement. Although the Memorandum of Understanding is not legally binding and cannot be relied on by asylum seekers, the Home Secretary says that Rwanda can be relied on to comply with it. There are financial incentives for Rwanda to comply with the memorandum, and it establishes arrangements for monitoring Rwanda's compliance. As against that, UNHCR, the United Nations Refugee Agency, has produced evidence of a number of deficiencies in the Rwandan asylum system. The relevance of that evidence is that if claims are not dealt with properly, then genuine claims are liable to be wrongly refused. And when claims are refused, Rwanda is entitled, under the memorandum, to expel the claimants to any country where they have a right to reside. The only country where most people have a right to reside is their country of origin. So if Rwanda does not have an adequate system for processing asylum claims, genuine refugees may be returned to their countries of origin. In other words, they may be subject to refoulement. In addition, UNHCR has produced evidence of a substantial number of cases of refoulement of asylum seekers by the Rwandan authorities, including during the period since a Memorandum of Understanding with the UK was concluded. It has also produced evidence of Rwanda's failure to comply with a similar agreement which it entered into with Israel. When this case came before the Divisional Court, it failed to give proper consideration to UNHCR's evidence. That was a mistake. UNHCR has unrivaled practical experience of the working of the asylum system in Rwanda through long years of involvement there, and its evidence requires careful consideration. So the Court of Appeal was right to overturn the High Court's decision and to consider the evidence again for itself. It concluded by a majority that asylum seekers who are sent to Rwanda are at real risk of refoulement, and that the policy is therefore unlawful. The question for this court is whether they were entitled to reach that conclusion on the evidence. The Court of Appeal based their conclusion on the following evidence. First, Rwanda has a poor human rights record. In recent times, British police have had to warn Rwandan nationals living in the UK of credible plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture. There are also concerns about media and political freedom in Rwanda. Since Rwanda has ratified many international human rights conventions, this evidence raises questions as to its compliance with its international obligations. It's also relevant to the question whether the Rwandan courts can be expected to act independently of the Rwandan government when deciding appeals against the Rwandan government's decisions on asylum claims. Secondly, UNHCR's evidence is that there are systemic defects in Rwanda's procedures and institutions for processing asylum claims. To mention only some of the points raised, they include, first, concerns about the asylum process itself, such as the lack of legal representation, the risk that judges and lawyers will not act independently of the government in politically sensitive cases, and the fact that the right of appeal to the High Court, which has existed in theory since 2018, has never, in fact, been exercised. Secondly, Rwanda's 100% rate of rejection of asylum claims from countries in known conflict zones from which asylum seekers removed from the UK may well come, such as Syria, Yemen, and Afghanistan, although the UK authorities often find that such claims are well-founded. Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples, which continued during the period after the UK's agreement with Rwanda was concluded. And fourthly, the Rwandan government's apparent misunderstanding of its obligations under the Refugee Convention. The third matter raised is, in UNHCR's evidence, is Rwanda's failure to fulfill undertakings which it gave to the government of Israel under an agreement for the removal of asylum seekers from Israel to Rwanda, which operated between 2013 and 2018. In terms of the agreement, asylum seekers sent from Israel to Rwanda were to be allowed to claim asylum there, and there was an explicit undertaking by Rwanda to comply with the principle of non-refoulement. The agreement was therefore similar in those respects to Rwanda's agreement with the UK. Despite the terms of the agreement, asylum seekers who were sent to Rwanda by the Israeli government were routinely moved clandestinely to a neighbouring country from which they were liable to be refouled. That evidence is not contradicted, and it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on. As I've explained, the legal test which has to be applied in this case is whether there are substantial grounds for believing that asylum seekers sent to Rwanda would be at real risk of refoulement. In the light of the evidence which I have summarised, the Court of Appeal concluded that there were such grounds. We are unanimously of the view that they were entitled to reach that conclusion. Indeed, having been taken through the evidence ourselves, we agree with their conclusion. We accept the Home Secretary's submission that the Rwandan government entered into the agreement in good faith, and that the capacity of the Rwandan system to produce accurate and fair decisions can and will be built up. Nevertheless, asking ourselves whether there were substantial grounds for believing that a real risk of refoulement existed at the relevant time, we have concluded that there were. The changes needed to eliminate the risk of refoulement may be delivered in the future, but they have not been shown to be in place now. The Home Secretary's appeal is therefore dismissed. There is also a cross-appeal on behalf of one of the asylum claimants who argues that the Rwandan policy is in breach of retained EU law, as well as being unlawful for the reasons that I've already explained. We reject that argument on the basis that under an Act of Parliament enacted in 2020, the EU provisions in question ceased to have effect at the end of that year. The cross-appeal is therefore also dismissed. The court will now adjourn.